number then consecutively. And WS ଯେତେବେଳେ ଆପଣ written statement ଯେତେବେଳେ ଦେବେ, similarly written statement ବି ଆପଣ consecutively para କରିକି ଦେବେ, ଆଉ in answer to all the para that have been written in the plaint you have to answer कि para number 1 is denied, or para number 2 I have no knowledge of, para number 3 I admit, para number 4 ର reply ରେ ମୁଁ ଏହା କହୁଛି ଯେ ସେ ନା ଏଇଟା ମିଛ କଥା କାହିଁକି ନା actually ଏମିତି ହେଇଥିଲା. So you have to give in reply in that particular order only. ତାପରେ ଆଉ ଗୋଟେ କଥା କହିଲା କଣ, ଆଉ ଗୋଟେ ରୁଲ ଯେ ଡେଟ୍ ଆଉ ସମ୍ ଯଦି କିଛି ମେନସନ କରିବାର ଅଛି ପ୍ଲିଡିଂସ୍ ରେ, those are to be written both in figures and words. What is the purpose? କାହିଁକିନା ଗୋଟେ ସପୋଜ ମୁଁ ଡେଟ୍ ଟାକୁ ଖାଲି ଲେଖିଦେବି, ଗୋଟେ ନମ୍ବର ହିଁ ଭୁଲ ହେଇଗଲେ ଡେଟ୍ ଟା ଭୁଲ ହେଇଗଲା, ସମ୍ ଟା ଗୋଟେ ଲେଖିଦେଲି, ଗୋଟେ ଜିରୋ ମିସ୍ ଆଉଟ୍ ହେଇଗଲେ ଇଟ୍ ଇଜ ବ୍ରିଙ୍ଗିଂ ଆଉଟ୍ ଡିଫରେଣ୍ଟ ସମ୍ ଅଲ୍ ଟୁଗେଦର. ଏଟା ତ jurisdiction କୁ ବି, pecuniary jurisdiction କୁ ବି hit କରିପାରେ କୋର୍ଟ ର. So for that matter you have to be very specific, and while writing date or sum you have to mention both in figures as well as in words. Rule 3 କହିଲା ଯେତେବେଳେ ପ୍ଲିଡିଂ ଯଦି କିଛି ପ୍ରେସ୍କ୍ରାଇବ ହେଇଛି appendix A ରେ ଯେ ଏଇ ପ୍ଲିଡିଂ ଏଇ ସୁଟ୍ ର ପ୍ଲିଡିଂ ଟା ଆପଣ ଏଇ ଫର୍ମ ରେ ଲେଖିବେ, ତାହେଲେ ଆପଣଙ୍କୁ ସେଇ ଫର୍ମ ରେ ଲେଖିବାକୁ ପଡିବ. appendix A ରେ ଯଦି ପ୍ରେସ୍କ୍ରାଇବ ହେଇଛି ଯେ there is a form in which form you have to be writing the pleading, then you have to write the pleading in that particular form only. Rule 3 ରେ ବି ଗୋଟେ amendment କରି କହିଛି commercial dispute ଯଦି ହେଇଥିବ ଆଉ ସେ commercial dispute ର ଗୋଟେ particular form ଥିବ, then pleadings are to be written in that form only. Rule 3 is which is more or less very easy to understand, so I am not harping on that. Rule 4 को ଏବେ ଚାଲିବା. ସେ କହୁଛି ଯଦି ଗୋଟେ coercion, undue influence, breach of trust, willful default, misrepresentation এই ସବୁ କୁ ଆପଣ plead କରୁଛନ୍ତି, then they are to be very specifically pleaded. How you were put under coercion, how someone unduly influenced you so that you were bound to make a document in their favor. ଯଦି ଆପଣ ଏଟା ଗୋଟେ allegation କରୁଛନ୍ତି ଯେ ଇଏ ମତେ ଜବରଦସ୍ତି କରିକି ମତେ ଗୋଟେ undue influence ରେ ରଖି କରିଦେଲା, କି coercion କରିକି ବାଧ୍ୟ କରି କରିଦେଲା, ମୋ ଛୁଆକୁ kidnap କରିକି ନେଇକି ମତେ କହିଲା ଯଦି ତୁ ସାଇନ ନ କରିବୁ ତାହେଲେ ମୁଁ ତୋର ଛୁଆକୁ ମାରିଦେବି, ମୁଁ ମୋ ଛୁଆକୁ ବହୁତ ଭଲ ପାଏ, ମୁଁ କଣ କଲି ନା ସାଇନ କରିଦେବି. So in that case it will be pleaded specifically. ତାପରେ ଆସିଲା condition precedent. Condition precedent କଣ କହୁଛି ଯେ condition precedent ଯଦି ଗୋଟେ କୋଉ ବି ଜିନିଷର ଗୋଟେ condition precedent ଅଛି. What is the condition precedent? ମୁଁ ଗୋଟେ contract ରେ ମୁଁ ଗୋଟେ ରଖିଲି, for example ମୋର ବାପା ମତେ କହିଲେ ଯେ ଆଜି ଯଦି ତୁ ୟୁପିଏସସି କ୍ଲିୟର କରିବୁ ତାହେଲେ ମୋର ଯାହା ପ୍ରପର୍ଟି ସବୁ ତୋ ନାଁରେ କରିଦେବି. This is a condition precedent. So condition precedent ଯଦି ମୁଁ ତାର performance ଟାକୁ plead କରିବି, that need not be pleaded. କାହିଁକିନା ମୁଁ ଯଦି condition precedent ଟା ଲେଖିଲି ମାନେ ଆଉ ତାର fulfillment ଟା ହେଇଯାଇଛି, ତାହେଲେ I need not plead that. But ଯଦି ମୁଁ allegation କରୁଛି ଯେ ଏଇ condition precedent ଟା ଥିଲା ସେଥିପାଇଁ ମୁଁ ଡକୁମେଣ୍ଟ ଟା ତାକୁ ଦେଲିନି, ତାହେଲେ ସେଇ ଯୋଉ condition precedent ର non fulfillment ଟା or non performance ଟା, that has to be specifically pleaded. କାହିଁକି ନା court will not from its own volition presume କି ଆପଣ condition precedent ଟା fulfill ହେଇଛି କି ହେଇନି. ଯଦି ଆପଣ plead ନ କରିଛନ୍ତି it will be presumed that condition precedent fulfill ହେଇଛି, still ଆପଣ କାହିଁ contract ଟା କଲେନି, or still ଆପଣ କାହିଁ document ଟା ତା favor execute କଲେନି. ସେଥିପାଇଁ ଯଦି non performance of the condition precedent, this rule says, then it has to be pleaded very specifically. ତାପରେ ଗୋଟେ ଆସିଲା rule departure. What is the rule of departure? that ଆପଣ pleadings ରୁ inconsistent ହେଇକି କିଛି ବି plead କରିପାରିବେ. ଯେ ଗୋଟେ pleading ଯାହା ଆପଣ କରିଛନ୍ତି ତାକୁ inconsistent କରିକି ପୁଣି ଆହୁରି ଗୋଟେ ଅଲଗା ଜିନିଷ plead କରିବା, you can't plead that. You can't plead something which is inconsistent to the pleadings. But of course ଆପଣ ଯଦି plead କରିବାକୁ ଚାହୁଁଛନ୍ତି ଗୋଟେ ଜିନିଷ ଯୋଉଟା କି ଲାଗୁଛି ଆପଣ inconsistent ହେଇଯାଉଛି previous pleading ରୁ, ତାହେଲେ ଆପଣ କଣ କରିବେ ନା amendment ପାଇଁ ପ୍ରେ କରିଦେବେ. amendment କଲା ପରେ you can plead anything, but inconsistent ହବା ଦରକାର ନାହିଁ. ଗୋଟେ pleading ରେ ଲେଖୁଛନ୍ତି ଆପଣ ଯେ I am praying for ମାନେ annulment of the contract because the contract is void, କି contract ଟାକୁ ମୁଁ void ବୋଲି, contract ଟା void, କିଛି ମୋର ତା ସହିତ contract ହେଇନି, नेक्स्ट पुणी आपण प्लीडिंग रे लिखलेनी जे आई वांट दी स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट. These all are very inconsistent to each other. ଆପଣ either କହିବେ void ନହେଲେ କହିବେ specific performance ପାଇଁ ମାଗୁଛନ୍ତି ଯଦି ତାହେଲେ ଆପଣ ତ void କହିପାରିବେନି. ଯଦି void କହୁଛନ୍ତି ତାହେଲେ specific performance ମାଗିପାରିବେନି. So these two are inconsistent. ତେଣୁ ଦିଟାକ ଆପଣ ଏମିତି plead କରିପାରିବେ ନାହିଁ. ଏଇଠି ଗୋଟେ ଦିଟା କନସେପ୍ଟ ଆସିବ. ଗୋଟେ ହଉଛି alternate pleading କଣ, ଗୋଟେ ହଉଛି inconsistent pleading କଣ. What is an alternate pleading? What is an inconsistent pleading? ତ alternate pleading କଣ, ଯେ ଯେତେବେଳେ ଦିଟା set of facts or two sets of facts or two sets of release are claimed in the alternative, then that will be called alternate pleading. But inconsistent pleading କଣ, ଯେ mutually repugnant pleading. ମାନେ one pleading is destructive of the other. ତା ମାନେ ଆପଣଙ୍କୁ example ଦଉଛି, ଗୋଟେ alternate pleading ଆଉ inconsistent pleading ର example ଦଉଛି. alternate pleading ର ଗୋଟେ example ହେଲା ଯେ ଆପଣ plea କଲେ ଯେ ମୁଁ ମୋର ଗୋଟେ ହାଉସ ଯୋଉ ଲ୍ୟାଣ୍ଡଲର୍ଡ ଟା ମତେ ଏଭିକ୍ଟ କରିବାକୁ ଚାହୁଁଛି. ଏଭିକ୍ଟ କଲା ବେଳକୁ ସେ ମତେ କହିବ ଯେ ନାଇଁ ମତେ ସେ ମତେ ଭଡା ଦଉନି ସେଥିପାଇଁ ମୁଁ ତାକୁ ଏଭିକ୍ଟ କରୁଛି. ତାର ଅଲ୍ଟରନେଟିଭ କହିଲା ମୋର ବି ଏୟା ବି ମତେ ବି ପର୍ସନାଲି ରିକ୍ୱାରମେଣ୍ଟ ଅଛି, ମୋ ଝିଅ ଆସୁଛି ସେଥିପାଇଁ ମୁଁ ତାକୁ ଏଭିକ୍ଟ କରୁଛି. So these are two pleadings which are probably alternate to each other, but they are not inconsistent because one is not killing the other. ସେଥିରେ କହିଲା ଯେ ରେଣ୍ଟ ଦଉନି ଦଉନି, ତାପରେ ଆଉ ଗୋଟେ କହିଲା ଯେ ମୋର ପର୍ସନାଲ ଗ୍ରାଉଣ୍ଡ ବି ଅଛି. So these are not inconsistent to each other. But ମୁଁ ତମକୁ ଆଉ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ଦଉଛି how it will be inconsistent. ମୁଁ କହିଲି ଯେ ଟାଇଟଲ ବେସ୍ଡ ପୋଜେସନ ମୁଁ କ୍ଲେମ କରୁଛି ଗୋଟେରେ, ଟାଇଟଲ କ୍ଲେମ କରୁଛି ଗୋଟେରେ, ଟାଇଟଲ କ୍ଲେମ କଲା ବେଳକୁ ତାର ଅଲ୍ଟରନେଟିଭରେ ମୁଁ କରୁଛି ଆଡଭର୍ସ ପୋଜିସନ କ୍ଲେମ କରୁଛି. ଯଦି ମୁଁ ସେମିତି କଲି, ଆପଣ ଜାଣିଥିବେ ଆଡଭର୍ସ ପୋଜିସନ ଯଦି କିଏ ପଢିଥିବେ ଜାଣିଥିବେ ଯେ ଆଡଭର୍ସ ପୋଜିସନ ରେ ଇଟ ଦି ଫର୍ଷ୍ଟ ଆଣ୍ଡ ଫୋରମୋଷ୍ଟ ଏଲିମେଣ୍ଟ ଇଜ କି ଆପଣଙ୍କର ଟାଇଟଲ ହିଁ ନାହିଁ. ଆପଣ ଟାଇଟଲ ନଥିଲା ବେଳେ ଆପଣ ଟାଇଟଲ କ୍ଲେମ କରୁଛନ୍ତି ଆଡଭର୍ସ ପୋଜିସନ. ଯଦି ଆପଣ ଟାଇଟଲ ଅଛି ତାହେଲେ ଆପଣ ଆଡଭର୍ସ ପୋଜିସନ କେମିତି କ୍ଲେମ କରିପାରିବେ? ତ these two are like କି two swords in the same chamber, so you can't keep them both. ଆପଣ hot and cold ଆପଣ ଗୋଟେ ସାଙ୍ଗରେ you can't blow. So that is the reason କି ଆପଣ inconsistent pleading ଆଉ alternate pleading ଭିତରେ there is a thin line, but you have to understand and whether to allow the same or not. till ଆଉ ଗୋଟେ example ଦେଇଥିଲି ଯେ contract ରେ ମୁଁ କହିଲି ଯେ ଆରେ contract ଟା unlawful because the object thereof contract ଟା void because the object thereof is unlawful. କାହିଁକି object ଟା କଣ? object ଥିଲା କି ଏଟାକୁ ଏଠି brothel ଖୋଲିବ ବୋଲି ସେ ମୋ ଘରଟାକୁ ନଉଥିଲା. For that purpose I don't believe the contract should be allowed to be valid and it should be void because the object was unlawful. or gambling house କରିବାକୁ ଦଉଥିଲା ସେଥିପାଇଁ unlawful object, the contract is void. ତାର ଅଲ୍ଟରନେଟିଭରେ ମୁଁ କହୁଛି ଯେ specific performance of contract, he should be ମାନେ specifically enforced to perform that contract. No, I can't plead both because these are inconsistent to each other. Okay, I hope inconsistent ଆଉ alternate ଭିତରେ ଆପଣ କ୍ଲିୟର ହେଇଗଲେ. ତାପରେ rule 8 କହିଲା ଯଦି ଆପଣ ଗୋଟେ କଣ୍ଟ୍ରାକ୍ଟ ର ଲିଗାଲିଟି କୁ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି then that must be expressly pleaded. କଣ୍ଟ୍ରାକ୍ଟ ର ଲିଗାଲିଟି ଯଦି ଅଛି କୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି that must be expressly pleaded. Why? because ଯଦି ଆପଣ କଣ୍ଟ୍ରାକ୍ଟ କୁ ଡିନାଇ କଲେ ତା ମାନେ ଯେ fact that the contract was not executed, only that will be presumed by the court. Court will not presume from its own side that the contract was void or the contract was illegal or it was non-enforceable or whatever the case may be. No, court will not presume that. If you are alleging that the contract was legal or non-enforceable, then you have to expressly plead the same. Then comes rule 9. That is the how the documents will be pleaded. That normally documents आपण लिखला बेलକୁ एमति लिखिबे annexure form रे करा हबो. annexure form रे कला बेलକୁ that I am relying on the document as attached as annexure रे और एमति लिखिबे. but normally documents गुडा सेमति लिखिबे and it should be the documents रो ଗୋଟେ माने nomenclature करिकि it should be briefly stated. but केबे भी आपण लिखि परिबेनी जे डॉक्यूमेंट रो एई पार्ट रे एईटा लेखा हितला तेणु सेति पई मु भाबुची एटा जदि if it is that material or that relevant कि आपनकर पूरा सोल केस टा ही बेस करूची से डॉक्यूमेंट रो सही वर्ड्स ऊपर फॉर एग्जांपल आई गिव यू एन एग्जांपल कि गोटे पार्किंग टिकेट रे जदि आपनकर लेखा हिथिबो पूरा लेखा हिथिबो स्पेसिफिकल लेखा हिथिबो जे the owner is liable for the loss ସେଇଟାରେ ଆପଣଙ୍କର the suit can either stand or fall so ସେଇ ଯୋଉ ପୁରା particular word କୁ ମୁଁ stress କରୁଛି that has to be that needs to be that needs to be written specifically even though I need to briefly jot down the documents still then because if it is that relevant I can exactly produce the words that are mentioned in the document at length. Rule 10 कौन कहला rule 10 कोची malice intention or knowledge these things or anything which is the element of which is a mental element in nature for example motive ମୁଁ ମାନେ ତାର intention ଟା ତାର knowledge ରେ ଏଟା ଥିଲା कि ସେ grossly ଚଲଉଥିଲା कि ସେ negligently conduct କରିଛି all these are mental elements ଯଦି ମୁଁ specifically ଏଟାକୁ plead ନ କରିବି then it will not be known ki what is the thing that I'm alleging because tar upare mor pura suit ta lie karuchi that case all these things have to be pleaded specifically but yes you need not plead the circumstances in which the you were sure that he had the motive or he had the knowledge ସେଗୁଡା ସବୁ ଆପଣ ଏଭିଡେନ୍ସ ରେ ଦେବେ କାହିଁକି ଆପଣ ଯଦି ଏବେ ଲେଖିଦେବେ ଯେ ଫାର୍ଷ୍ଟ ମୁଁ ଏକ୍ସାମ୍ପଲ ଦେଇ ଦଉଛି ଯେ ମୁଁ କହୁଛି ମୁଁ ଆଲେଜ କରୁଛି ଯେ A had the knowledge that A had the motive or he had the intention of killing me or killing B or executing a false document and that's the reason ସେ ତାକୁ ସେ କଣ କରିଛି ନା ସିଗ୍ନେଚର ଟା ଗୋଟେ ଅଲଗା ଟାଇପ ର କରିଛି ଏଟା ଯଦି ଆଲେଜ କରୁଛି ତ ସେଇଠି ଯୋଉ ଆଲେଜ ଟା କଲି ଯେ ଯୋଉ ଇଣ୍ଟେନସନ ଅର ମୋଟିଭ ଅର ନଲେଜ ସେଟା ଜାଣିକି ଯୋଉ କରିଛି ଭୁଲ ରେ ଜାଣି ଶୁଣିକି ଫଲ୍ସ ସିଗ୍ନେଚର କରିଛି ଡକ୍ୟୁମେଣ୍ଟସ ଉପରେ ସେଇଟାକୁ ମୁଁ ସ୍ପେସିଫିକାଲି ପ୍ଲିଡ କରିବି ବଟ୍ ମୁଁ କେମିତି ଜାଣିଲି ତାର ଫଲ୍ସ ସିଗ୍ନେଚର କରିଛି ସେଟା ସବୁ ମତେ ପ୍ଲିଡ କରିବା ଦରକାର ନାହିଁ ଅଲ୍ ଦିସ୍ ଆର୍ ଏଭିଡେନ୍ସ ଥିଙ୍ଗ ଫାକ୍ଟା ପ୍ରୋବାନ୍ସିଆ ଫାକ୍ଟା ପ୍ରୋବାଣ୍ଡା ସବୁବେଳେ ଜାଣିବେ ଫାକ୍ଟା ପ୍ରୋବାଣ୍ଡା ଫାକ୍ଟା ପ୍ରୋବାନ୍ସିଆ ରେ ଡିଫରେନ୍ସ କରିଦେବେ କୋଉଟା ପ୍ଲିଡ କରାହବ କୋଉଟା ପ୍ଲିଡ ନ କରାହବ ୟୁ ୱିଲ୍ ବି ଭେରି ୱେଲ୍ ନୋନ୍ ଅଫ୍ କି ଆପଣ ଜାଣିଦେବେ
Excuse me, sir.
ଏଇଟାକୁ ପ୍ଲିଡ କରିବା କଥା ଏଟାକୁ ପ୍ଲିଡ କରିବା କଥା ନୁହଁ
Excuse me, sir.
ତାପରେ ଆସିଲା yes
Sir, ସେଥିରେ ଲେଖା ହେଇଛି condition of mind.
ଯେତେ
Condition of
ଡାଉଟ
the
ଅଛି
mind of the person.
ପ୍ରଶାନ୍ତ ଡାଉଟ ଗୁଡା
Sir,
ଏଣ୍ଡ ଅଫ ଦି କ୍ଲାସ ରଖ ନହେଲେ ପୁଣି ସେଟା ଫ୍ଲୋ ଖରାପ ହେଇଯାଏ ଯାହା ଡାଉଟ ଅଛି
sir,
କ୍ଲାସ
okay,
ର
sir.
ଏଣ୍ଡ ରେ ରଖ ନୋଟ କରି ରଖ ଡାଉଟ ରେ ଲାଷ୍ଟ କୁ ପଚାର ହେଲା ହଁ ଲାଷ୍ଟ କ୍ଲାସ ର ଏଣ୍ଡ କୁ ପଚାର ରୁଲ 11 କଣ କହୁଛି ଯଦି ନୋଟିସ ଗୋଟେ ଅଛି ନୋଟିସ ଟାକୁ ଆପଣ ପ୍ଲିଡ କରୁଛନ୍ତି ଯଦି ସେଟା କଣ୍ଡିସନ ପ୍ରେସିଡେଣ୍ଟ ହିସାବରେ ଅଛି ଫର ଏକ୍ସାମ୍ପଲ ମୁଁ ପ୍ଲିଡ କରୁଛି ଯେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୁ ଯୋଉ ନୋଟିସ ଦବା କଥା ସେକ୍ସନ 80 ରେ ସେ ନୋଟିସ ଟା ମୁଁ ଦେଇଛି ଦ୍ୟାଟ ଇଜ ଏ କଣ୍ଡିସନ ପ୍ରେସିଡେଣ୍ଟ ତା ବିନା ସୁଟ ହେଇପାରିବନି ସେଇ ଯୋଉ ନୋଟିସ ଟା ମୁଁ ଦେଇଛି ଦ୍ୟାଟ ହାଜ ଟୁ ବି ପ୍ଲିଡେଡ ଆଜ ଏ ଫ୍ୟାକ୍ଟ ମୁଁ ଯାଇଥିଲି କଲେକ୍ଟର ଅଫିସ କୁ ଯାଇକି ତାକୁ କହିଲି ଦେଲି ତାପରେ ସେଠି ପିଅନ ଥିଲା ପିଅନ ଆସିକି ସାର୍ ମୁଁ ଡାକିଲା all these things specific terms or circumstances from which it is to be it is inferred that notice was given those need not be mentioned because then again ଏଟା ଫ୍ୟାକ୍ଟା ପ୍ରୋବାନ୍ସିଆ ହେଇଯାଉଛି ଫ୍ୟାକ୍ଟା ପ୍ରୋବାଣ୍ଡା ହିଁ ଆପଣଙ୍କୁ ମେନସନ କରିବାର ଅଛି ତ ଆପଣ ନୋଟିସ ଯଦି ରିକ୍ୱାର ଅଛି ଗୋଟେ କଣ୍ଡିସନ ପ୍ରେସିଡେଣ୍ଟ ଭଳିଆ ଟୁ ଫାଇଲ ଏ ସୁଟ୍ then that is to be pleaded as a fact and not the circumstances in which the notice was served ସେଟା ଦରକାର next comes implied contract or relationship to be pleaded ଯଦି ଆପଣଙ୍କର ଗୋଟେ implied contract ଅଛି or implied relationship ଅଛି ଯୋଉଟା କି ଇନଫର କରାହବ କୋଉଥିରୁ ଗୋଟେ series of letters or conversations ରୁ then this has to be specifically pleaded as well ତ କଣ କହିଲା ଯେ ସପୋଜ ଏକ୍ସାମ୍ପଲ ଦେଲେ ଆପଣ ବୁଝିପାରିବେ ଯେ ମୋର ମାନେ ରାମର ଶ୍ୟାମ ସହିତ କଣ ରିଲେସନ ଥିଲା ଏଜେଣ୍ଟ ପ୍ରିନ୍ସିପାଲ ରିଲେସନ ଥିଲା ଡାଇରେକ୍ଟଲି ସେ କେବେ ଆପଏଣ୍ଟ କରିନାହାନ୍ତି କିନ୍ତୁ ତାଙ୍କର କଥାରେ ଆପଣର ମେସେଜ ରୁ ଜାଣିପାରିବେ ଆପଣ ଇମେଲ ର କନଭରସେସନ ଆପଣ ଜାଣିପାରୁଛନ୍ତି ଯେ ଓକେ ପ୍ରୋବାବଲି ଦେ ହ୍ୟାଡ ଦି ରିଲେସନशिप ଅଫ ଏ ପ୍ରିନ୍ସିପାଲ ଏଣ୍ଡ ଏଜେଣ୍ଟ और ତାଙ୍କର ଯୋଉ ସପୋଜ ୟୁ ଆର ଆଲିଜିଂ ଏନ୍ ଏକ୍ସଟ୍ରା ମ୍ୟାରିଟାଲ अफेयर In that case ଆପଣ WhatsApp message or text message ର conversation ରୁ you are implying the relation because ତାଙ୍କର କିଛି express relation ତ ଥିଲା, they were not married. ତ ଯୋଉ implied relation ଟା ଆପଣ allege କରୁଛନ୍ତି that has to be specifically pleaded if they are to be inferred from a series of letters or conversations. Next rule says that presumption of law ସେଇଗୁଡାକ କଣ ପ୍ଲିଡ୍ କରାହବ ନା କରାହବନି. Presumption of law ଯଦି ଅଛି, they are not to be pleaded. Why? Because law is already taking a presumption, and it is not in your court to do the same. Other party को disprove କରିବାକୁ ପଡିବ ତାକୁ. ଗୋଟେ presumption of law ଅଛି ଯଦି, then the other party has to disprove how he has not committed the same or how he has not done the same. ତ ଆପଣଙ୍କୁ ସେଥିରେ ଆପଣ specifically proof mention କରିବା ଦରକାର ନାହିଁ ଯେ this presumption of law lies in my favor that this has to be looked into. No, you need not write that because law will take its course automatically. ଆପଣ channelize କରିବାକୁ try କରନ୍ତୁ ନ କରନ୍ତୁ, it will take its course. It is like a river which will flow. ଆପଣ ଅଟକାନ୍ତୁ ନ ଅଟକାନ୍ତୁ, you may put a boundary, you may try to stop it for some time, but it will definitely overcome that and it will flow. So ଆପଣ ଏଠି presumption of law କୁ ଆପଣ plead କରିବେନି. Yes, of course, କେତେବେଳେ presumption law ତାର exception ଅଛି, presumption law କେତେବେଳେ ଆପଣ plead କରିବେ. For example, ଯଦି ସେ first ରୁ ହିଁ deny କରିଦେଲା, ଗୋଟେ defendant favor ଗୋଟେ presumption of law ଅଛି, plaintiff କଣ କଲା ନା first ରୁ ହିଁ deny କରିଦେଲା, this presumption of law ଯୋଉଟା ଅଛି that is not ମୁଁ ସେଇ ଯୋଉ condition ଟା ସେଇଟା ମୋର fulfill ହଉନି, ସେଥିପାଇଁ I am denying that presumption. ସେଇ ଯଦି deny ଟା ହେଇଗଲା, ସେତେବେଳେ defendant ଯେତେବେଳେ written statement ଦବ, ଯୋଉ pleading ଦବ, ସେତେବେଳେ ସେ presumption law ଟାକୁ specifically plead କରିପାରିବେ, but not right away. ଆପଣ ଯଦି other party is not disputing that, ଆପଣ ଜବରଦସ୍ତି କାଇଁ ଖାଲିଟାରେ presumption law ଟାକୁ plead କରିବେ. Next comes pleadings to be signed by the party or pleader. This is a very peculiar provision. ମୁଁ ଏବେ ପଢିଲା ବେଳକୁ ହିଁ ଦେଖିଲି ଯେ ସେଥିରେ କହୁଛି ଯେ party or pleader କହୁଛି. So it will be signed by party or pleader. That means party ନ କରି ଖାଲି pleader କଲେ ବି ଚଳିବ, sign ଖାଲି pleader କଲେ ବି ଚଳିବ ବୋଲି as per my understanding and my interpretation it says ki party ଯଦି କଲେ ବି ଚଳିବ, pleader ଯଦି ଖାଲି ତାର advocate ବି notice କର, advocate ଯଦି ଖାଲି plaintiff ଲେଖିକି ମାନେ plaintiff ଲେଖିକି on behalf of the plaintiff ଲେଖିକି file କରିଦବ, then that is fine. But of course rule 15 ରେ again it is saying ki verification has to be done by party or any one of the party or anyone who is acquainted with the facts of the case. Probably that throws the fact that the ଗୋଟେ advocate asi khali file kar dei palebo, probably that is being taken care of by rule 15. But rule 14 कहि देउची जे pleadings करताकू sign करिया दरकार किए party or pleader जे भी कले चलिबो, बहुत कले भी चलिबो, जणे कले भी चलिबो. rule 14a टा कहूची address for service of notice. Address for service of notice, it is very important again, काहे कि ना आपण जति बहुत टाइम रे आपण को देखिबे it will be alleged that कि address टा ठीक नथिला, सेत नोटिस ही पलानी, बिकॉज़ आपण जानछि गोटे एक्सपर्टे हुए, एक्सपर्टे हुअंती पार्टी जले एक्सपर्टे हुअंती, सेतले तांको एब्सेंस रे गोटे डिसीजन निया जाय. सो जो से जो एब्सेंस रे डिसीजन निया जाय, इट इज प्रोबब्ली very erroneous according to law for the fact that ki it is a other party is not present and we are probably violating the principles of natural justice, and still then we are taking an action against him. So in that case एटा बहुत important है जा whether address टा correct ना नहीं. तो से address पई address for service of notice पई rule 14 रे provision कहला जे जेतले pleading के भी दबो से कोन करियो ना गोटे फॉर्म अछि जोथरे के एड्रेस दबा पड़िबो, गोटे स्पेसिफाइड फॉर्म अछि जतरे आपण एड्रेस ओडा को लिखि की देबे. इट कैन बी चेंज फ्रॉम टाइम टू टाइम. ते एड्रेस को आपण चाहिबे जदी चेंज कर करे, आपण रजिस्टर्ड एड्रेस चेंज करियो चाहउछंदी, यस आपण पुनी सेही गोटे स्पेसिफाइड फॉर्म अछि देकी आपण चेंज करबार ले चेंज ऑफ एड्रेस हे करियो. सेही जो एड्रेस आपण देइथिबे दैट विल बी ट्रीटेड एज योर रजिस्टर्ड एड्रेस before the court, and court can issue processes to that address. And सेटा पूरा फाइनल जे परंत एग्जीक्यूशन नै कि जे परंत न होई, unless of course it is changed, it will be holding good and 2 years thereafter. कैन आउ जदी कोन किछि असुविधा है कि कोन काले आपण चेंज करिया चाहिबे कि कोन किछि लीगल कॉम्प्लिकेशन अराइज करि परे, सेत पई 2 years पर्यंत भी होल्ड गुड करियो बोली कहिछि ऑफ कोर्स आ गोटे भी कोर्ट को पावर देला या कोन जदि आपण ठीक एड्रेस दो नांती इफ यू आर नॉट फर्निशिंग द करेक्ट एड्रेस then the court can either stay the suit which will be against the interest of the plaintiff or can strike down the defense जदि से डिफेंडेंट भी दबनी तार डिफेंस को भी स्ट्राइक डाउन करि परिबो कोर्ट पाखरे पावर टा रहला से जो ऑर्डर टा होउजी ऑर्डर करिबो आइदर टू स्टे द सूट और स्ट्राइक डाउन द thing that can be set aside जदि से satisfy हेवे that it is to be नहीं जदि से पार्टी satisfy करिवो नहीं नहीं मु जान नथिली मु भूल रे एड्रेस टा देइनी और मु देइथिली बट चेंज हे जाईची एबे मु भूल रे देइनी व्हाटएवर जदि से कोर्ट satisfy कर देला then that can be set aside as well तापर असला कोन court can सर्विस प्रोसेस एट डिफरेंट एड्रेस आल्सो जदि कोर्ट चाहिबो ताले से एड्रेस छाडी की जो रजिस्टर्ड एड्रेस छाडी की जदि से माने असर्टन कला जे रजिस्टर्ड एड्रेस कोटे पार्टी देजी किंतु से हैव टू प्ले हाइड एंड सीक विद द कोर्ट इज स्टेइंग एट डिफरेंट एड्रेस सेडू पोस्टमैन सब तरह जाउची डोर लॉक्ड करके देर की पळे आछि कोर्ट कैन नॉट जस्ट सिट ओवर इट कोर्ट कोन करबो ना जदि चाहिबो ओटा अल्टरनेट एड्रेस को भी पठै परिबो दैट इज व्हाट रूल 14 सेज Rule 15 कहला verification of pleading by parties or any one of the parties or any person who is acquainted with the facts of the case. सेटा को verify करिवे जे नहीं नहीं एई जोडा लिखा हिची एटा आई अमक अमक verify that these are true to the best of my knowledge and belief and I after reading the contents thereof and ascertaining the same to be true I'm putting my signature thereon ओडे आपण ओडे verification ओडे देबे सेटा कहला rule 15 रूल 16 को कहूची स्ट्राइकिंग आउट प्लीडिंग जे कोर्ट चाहिबो जदी आपनकर प्लीडिंग को स्ट्राइक डाउन करि परिबो दिस इज अ वेरी इंपोर्टेंट पावर अगेन वेस्टेड विथ द कोर्ट फॉर द फैक्ट दैट जदी आपण गोटे मन इच्छा लिखिबे जो जो सब जिंस कहली फैक्टा प्रोवेंडर न लिखि कि फैक्टा प्रोवेंशिया गुडा लिखि देले फैक्ट न लिखि कि लॉ गुडा लिखि देले एविडेंस गुडा लिखि देले जो जोठी आपण स्पेसिफिकली कहली कि जो जोडा प्लीड करिया कथा को कोडा प्लीड करिया कथा नो रूल्स सब कहि गय आसिली सेही सब रूल्स गुडा को भी आपण न फॉलो करी लिखि देले कोर्ट हैज द पावर दैट दे कैन स्ट्राइक डाउन द प्लीडिंग व्हेन जेतले से फैक्ट्स गुडा अननेसेसरी थिबो स्कैंडलस थिबो वेक्सेसियस थिबो फ्रिवलस थिबो डिले करथुबो प्रोसेस ऑफ द कोर्ट अब्यूज करथुबो पावर ऑफ द कोर्ट और ऑफ सच नेचर व्हिच इज माने এই সব জিনিসর এই সব নেচর যদি থিবো দেন ইট ক্যান ভেরি ওয়েল স্ট্রাইক আউট দি প্লিডিংস তাপরে ଗୋଟେ ବହୁତ important ସେକ୍ସନ ସବୁଥର ଆସୁଛି କ୍ୱେଶ୍ଚନ amendment of pleading it is equally important in the practical field as well because as I laid down कि ଆପଣ go भी pleading କରିବି ନାହାନ୍ତି ଯଦି ତାହେଲେ ତା ବିରୁଦ୍ଧରେ ଆପଣ evidence ଦେଇ ପାରିବେ matter being thus आपनको कोई भी एविडेंस दबा आगु प्लीडिंग रे इनकॉर्पोरेट करिया मस्ट जदी कोर्ट सेटर रे अमेंडमेंट अलाउ करिवेनी और अमेंडमेंट आपण करि परिवेनी ताले आपण तो एविडेंस दे परिवेनी तो आ बहुत टुडे टाइम रे आपण को एमता थिबो कि इट विल बी फर्स्ट नोन मान आपण को फर्स्ट जणा नथिबो बट तापर धीरे माने जतले केस रे डीप को पसिबे अलगा अलगा फैक्ट सब आसीबो अलगा अलगा एंगल सब आसीबो सो यू विल हैव टू बी कॉन्शियस इनफ कि आपण जति कि भाबिबे जे नाही जदी मोर गोटे नुवा फैक्ट आसिला मते अमेंडमेंट जाहले करके पुरे पड़िबो तापरे मु एविडेंस देकी मो केस टाको मेक आउट कर so for that amendment of pleadings becomes very important so it says that material facts and necessary particulars must be stated in the pleading so according to the amendment of pleadings rule it can be done at any stage and either party can apply for an amendment and when it will be done when it is just and necessary for determination of real questions and controversy between the party ता माने कोन जे फर्स्ट होची जे को भी स्टेज रे करि हबो को भी स्टेज रे तले करि हबो ता माने बिफोर ट्रायल आफ्टर ट्रायल बिफोर एडमिशन आफ्टर एडमिशन बिफोर इशू फ्रेम हला बेलकू सेता जतले ईडीआर पाखु जाइथिबो सेते बेलकू बिफोर प्रोनाउंसिएशन ऑफ जजमेंट आर्गुमेंट जो स्टेज रे भी थाउ अपील स्टेज रे भी पड़ो ना कहीं अपील इज ए कंटिन्यूएशन ऑफ ट्रायल So आपको जदि if anyone asks you whether appeal stage रे amendment allow करियबो काई करियबो करियबो at any stage कोजी करियबो तापरे either party can amend कि दी party के both parties can amend तापरे but गोटे subject to condition रहला जदि trial थरे commence करि जाउची then the court has to satisfy that even after due diligence the party could not have raised it before the trial सेही कंडीशन टा आपन को सैटिस्फाई करिया पड़िबो जदि ट्रायल कमेंस करि जाउची ताले आपन को सैटिस्फाई करिया पड़िबो कोर्ट को सैटिस्फाई करिया पड़िबो दैट कि नाइ नाइ मो नॉलेज रे सेटा नथिला आगुरु एबे आसिला बट यस बिफोर कमेंसमेंट ऑफ ट्रायल एट एनी स्टेज आपन आपन जदि भी आपन नॉलेज रे थिला ओ प्लीड कर नथिले still then court will liberally see it and can allow but after commencement of trial आपन को जहा ले satisfy करिया पड़िबो सेतरे आपन को इट कोर्ट may or may not depending upon the nature ki whether it is actually necessary for determination of real question of controversy so jo real question of controversy that is very important so what is a real question of controversy what is an unreal nature of controversy or unreal question of controversy or not substantial question of controversy so substantial question of controversy or real question of controversy is that controversy or that dispute jaha upare pura suit ta hinge करछि जदि मु सेईटा को मु डिसाइड न करिवि ताले किछि सूट नै डिसीजन मते मिलिबन दैट इज अ रियल क्वेश्चन ऑफ कंट्रोवर्सी सेई जो कंट्रोवर्सी टा और सेई डिस्प्यूट टा और एज मे बी देयर मे बी मेनी डिस्प्यूट जहा ऊपर सूट टा हिंज करछि इन दैट केस आपण से सेमति अमेंडमेंट को यू हैव टू अलाउ बट जदि गोटे अमेंडमेंट which is not material at all ता ऊपर real nature of controversy is not depending and then the court can very well reject it but of course ए जो आपन कहली before trial कोर्ट रो टिके व्यू टा lenient हबो but after trial टिके stricter view हबो in the sense it has to satisfy that आपन को knowledge रे नथिला से fact टा जोडा एबे आपन allege करछथि तो object of amendment kono no injustice is caused to any side because he had left out or he had forgotten or he had missed out or it was not in his knowledge for that purpose only sei yeটাକୁ ମାନେ justice ର purpose ଟାକୁ ଆପଣ check କରି ପାରିବେନି that is the reason amendment ଗୁଡାକୁ ଆପଣଙ୍କୁ allow କରାଯାଇଛି court କୁ ଯେ it can allow amendments in appropriate cases a Salem Advocates Bar Association versus UI रे it is a very important decision it is a very important decision जोथे कहैतला जे amendment केतेल allow करा हबो to determine the real question of controversy सेठी ensure कले सेठी apex court कहले जे before trial गोटे liberal construction मिलेबो but after trial टिके strict construction दिया हबो जेतरे कि आपन को satisfy करिवो पड़िवो court को that you even after due diligence even after you tried your best you could not procure that fact before trial or you could not produce that fact before trial now you have procured it and now you are in a position to procure it hence the court should allow it the leave to amend केतेबेले allow करा हबो जेतेबेले other party को injustice होनुथिबो first कथा second कथा होची it is necessary for determining the real question and controversy between the parties so basically जेते देखिए जेतेबेले आउडा amendment petition पड़े सेतेबेले एई दीटा कथाटा को साने जाहाले satisfy करिया को ट्राई करिए first होची जे जदि मु एटा को amendment allow करा जाए it will not cause any grave injustice to the other party एटा होची first कथाटा से प्रे करिवे सबले लिखिए मेंशन करिवे second कथाटा मेंशन करिए that it is also necessary for determining the real question in controversy between the parties ए दीटा कथा आपण लिखिबे ताहेले जे कि आपण दीटा को जदि आपण कोर्ट को सैटिस्फाई करले देन ओनली इट विल बी अलाउड तापरे आउटे कथा होची वेदर ए जो डिले टा को आपण डिले जो हैला अमेंडमेंट फाइल करिया रे जो आपण को नॉलेज रे सपोज गोटे एग्जांपल होची कि जे आपण को नॉलेज रे सेटा थिला बट आपण स्टिल अमेंडमेंट पे फाइल करिना तो ए जो फाइल करनांती जो आपनकर नॉलेज रे थिला और फाइल करनांती वेदर दैट कैन बी स्टिल कंडोन से जो डिलेटा चक्रेश्वरी कंस्ट्रक्शन केस रे कहला जब डिलेटा को प्रॉपर्ली एक्सप्लेन कराइसी देन आल्सो इफ इट वाज विद इन द नॉलेज दैट कैन बी कंडोन केमती फॉर एग्जांपल आपनकर नॉलेज रे आसिला 2019 2020 मार्च रे आपन नॉलेज रे आसिला जस्ट आपन नॉलेज आसिला आपन सेतल करिया कथा ता माने किंतु कोविड हे गला कोविड सिचुएशन आसी गला तापरे पुनी कमेंसमेंट हे कि ट्रायल आसी गलानी एबे ट्रायल हे गलानी ट्रायल को पळे आसला बेलू आपण एबे फाइल करचंदी आपण कोविड रो केस एबे फाइनली इंप्रूव करची तो आपण यू वांट टू कंडोन दैट डिले कि दो इट वाज विद इन माय नॉलेज इन मार्च 2020 because the 2 years have been taken away by covid let's mane the honorable court may kindly take it liberally and may allow such amendment by condoning the delay in filing such amendment. Yes, that can be done. Chapteswari construction case रे कहला but ଆଉ ଗୋଟେ କଥା ଆପଣଙ୍କୁ you have to be sure that ଆପଣ ଯଦି ଗୋଟେ ପାର୍ଟିରେ amendment allow କରୁଛନ୍ତି then consequential amendment ଟା other party କୁ allow କରିବାକୁ ପଡିବ କାରଣ ଆପଣ ପ୍ଲେଣ୍ଟରେ ଆପଣ ଗୋଟେ ଜିନିଷ amend କରିବାକୁ ଦେଲେ ତାକୁ ତ ଏବେ ତାକୁ ଆନ୍ସର ଯୋଉ କରିଥିଲା ରିଟର୍ନ ଷ୍ଟେଟମେଣ୍ଟ ରେ ସେଟା ତ ଗୋଟେ ପୁରା ଅଲଗା ଆନ୍ସର ହେଇଯିବ କାହିଁକିନା ସେ ପାରା 18 ରେ ଗୋଟେ ଜିନିଷ ଲେଖିଥିଲା ଯୋଉଟାକୁ ଇଏ ଲେଖିଥିଲା ଯେ ପାରା 18 ଇଜ ଡିନାଇଡ୍ ସ୍ପେସିଫିକାଲି କିଏ ଡିଫେଣ୍ଡେଣ୍ଟ ଲେଖିଥିଲା ଏବେ ସପୋଜ ଆପଣ ଡିଫେଣ୍ଡେଣ୍ଟ କୁ ଆଲାଉ କରୁନାହାନ୍ତି ଯେତେବେଳେ ପ୍ଲେନ୍ ଟା ଚେଞ୍ଜ ହେଇକି ପାରା 18 ଟାରେ ଗୋଟେ ଅଲଗା ଜିନିଷ ପଶିଗଲାଣି ଆପଣ ଏବେ ଡିଫେଣ୍ଡେଣ୍ଟ ରେ ସେଇ ଲେଖିଥିବ ପାରା 18 ଇଜ ଡିନାଇଡ୍ ସ୍ପେସିଫିକାଲି ବଟ୍ ପାରା 18 ଏବେ ଗୋଟେ ଅଲଗା ଜିନିଷ ତେଣୁ ସେଥିପାଇଁ ଆପଣ ରିଟର୍ନ ଷ୍ଟେଟମେଣ୍ଟ ରେ ବି ତାକୁ ମାନେ ଅପରଚୁନିଟି ଦେବେ ଅଦର ପାର୍ଟି କୁ that he also can avail that benefit of amendment. ତାପରେ ଆସିଲା leave to amend when refused. Leave to amend କେତେବେଳେ refuse କରାହବ when the amendment sought for is not necessary for determining the real questions and controversy. ଯଦି ସେଟା real question of controversy ପାଇଁ relate କରୁନି you can very well refuse the amendment. Second is when it changes the fundamental character of the suit. पूरा fundamental character of the suit को ही change कर दଉଛି. For example, first ରେ ମୁଁ କରିଥିଲି ଗୋଟେ suit for injunction कि ମୋ ଜାଗାରେ ଅଛି ସେ ପଶୁଛି ତେଣୁ ତାକୁ ଗୋଟେ injunct କରାଯାଉ ଏବେ suit title it is fundamentally changing the nature of ମୁଁ ଏବେ କହୁଛି ଯେ ମୋର title ଟା establish କରାଯାଉ it is changing the nature of the suit so fundamental change in nature of the suit जोटा होची character of the suit टाको आपण change करछंती that cannot be allowed as has been mentioned in the case of AK Gupta versus Damodar Valley corporation. Tapare third is when it is not be allowed when the effect of such amendment is to take away a legal right that has accrued to the other side. Eta Patil versus Patil case re कहला जदी से effect of such amendment is to take away a legal right that has accrued to the other side. In the meantime ଗୋଟେ legal right ଏବେ accrue ହେଇଛି other party को defendant को ଏବେ ଗୋଟେ legal right ଟା accrue ହେଇଛି ସେଇ legal right ଟାକୁ ଆପଣ accrue କରି ମାନେ ତାଠୁ ଛଡେଇ ନେବା ପାଇଁ ଆପଣ ଏବେ ଗୋଟେ fresh amendment କରୁଛନ୍ତି जोटा कि ସେତେବେଳେ ସେ suit ର part ବି ନଥିଲା no this cannot be allowed so for example कि ଏବେ ଗୋଟେ defendant ଟା ମାନେ ଆଗରୁ ସେ suit ଟା ଥିଲା ଯେ defendant ଆପଣଙ୍କ ଜାଗାରେ ପଶୁଛି और ଇଏ बट डिफेंडेंट को आपण से तार अधा पार्ट टा आपण बिकी सारलेनी सेई जो राइट टा एबे डिफेंडेंट को ऊपर अक्रू करि गेलानी सेई राइट को आपण छडै नेबा पय आपण गोटे अमेंडमेंट करछंती which will not be allowed because सेइथरे आपण you are taking away a right that has accrued to the other party in the interim. Fourth is if it is made with malafide intention. If the amendment is made with malafide intention, then such amendment will not be allowed. गोटे गोटे किछि intention ही मोर भूल कि just to frustrate the process of the court, just to abuse the process of the court, just to delay the process of the court, just to harass the other party. एई सब purpose जदि मु करछि then it will not be allowed. Of course, when I told you that it will be done at any stage, that means it can be done at any stage. After trial, before admission, after admission, so on. Yes, on terms fixed by the court, that means ଗୋଟେ cost fix କରିକି ଯଦି court ଚାହିଁବ amendment allow କରିବା ପାଇଁ ସେ ସବୁ କରିପାରିବ ତାହେଲେ ଯଦି ଆଉ ଏବେ ଆସିଲା ଯଦି amendment ହେଇଛି ତାର amendment ପାଇଁ ଆପଣ ପ୍ରେ କଲେ court ଯଦି ଆପଣଙ୍କୁ amendment grant କରିବ refuse କରିବ ସେ ଯୋଉ grant କରିବ ଆଉ refuse କରିବ that is not a decree and not an appellable order as well and hence ଆପଣଙ୍କର appeal ର right ନାହିଁ but of course revision ଆପଣ କରିପାରିବେ under 115 CPC you can revise that refusal or granting of amendment but you can't file an appeal against that କାହିଁକି ନା ଗୋଟେ case decided but not a decree or an appellable order rule 18 ତାର କହିଲା जे जदि लीव ग्रांट करा हला अमेंडमेंट पई ताहले the said has to be amended within 14 days or जदि किछि गोटे टाइम स्पेसिफाई करा है that order रे within that period you have to amend it. That time can be extended by the court, but जदि से time limit भितरे without extending the time limit you are not filing the amendment or you are not making the amendment, then your amendment will not be allowed. This is what the pleadings say. Order 6, our discussion on order 6 is hereby complete. uh, Please tell me if you have any doubt. I have very few minutes left with me because I'm traveling, but then if you have any doubts, Prashant was asking something. Prashant?
Sir, in Rule 10, malice, knowledge, and condition of the mind of any person, can we relate it with the Section 14 of Indian Evidence Act or any other section of Indian Evidence Act, sir?
You tell me, since you put that question, you tell me, can we relate it or not?
Yes, sir. Like condition of the mind of any person, can I connect Section 14 of Indian Evidence Act with this rule, sir?
You tell me, what can we relate or not?
Sir, I want to know the answer, sir.
I am sure you know the answer, Prashant. Since you put a very clever
Thank
question,
you,
I
sir.
am thinking that you know the answer.
Thank you, sir. And in Rule 17, amendment of pleading, in that portion, I have written Section 148 of CPC, sir, but I have forgotten the link between 148 CPC and that rule amendment of pleading something. Sir,
What
is
does
there any
148 say?
relevancy,
What
sir?
does
And
148?
enlargement of time. Sir, 1 minute.
What is it?
Sir, 1 minute. Rule 17, Rule 17, Order 6.
Yes, and
Amendment of pleading and section 148 CPC.
Where arithmetic error and all of that is alleged. 148. What is it? What does it
148
say? You have to say it.
enlargement of time, sir.
Enlargement of time.
Yes, sir. Really, I don't know the link. What is the relevancy between
Then
these
why are you
two
trying to
sections?
establish a link between enlargement of time
Sir, I
and
have written in my
amendment?
BRF, sir, section 148 CPC in Rule 17,
See,
sir. Amendment of pleading.
because you have written something, Prashant, I can't answer that question, I believe. Because there is
Sir,
no link
sir.
between 148 and Order 6, Rule 17. You are putting.
Anywhere I have read, but I have forgotten, sir. So why I asked, sir.
Prashant, let me
Sir,
clarify something. Just to show off,
yes,
you
sir.
don't ask any question. If there is a real
No, sir,
doubt,
not
I
to
am
show,
very
sir.
well.
Not to show, sir.
No, I have noticed, Prashant, you ask questions in order to show off that you are studying. Don't do that. Don't do that. That's a very wrong way of going about it. There is no link
No,
between
sir.
148 and Order 6, Rule 17 whatsoever. What is the link
Okay,
between
sir. Then
enlargement
I
of
will
time?
quote down it. Okay, sir. I
Yes,
will quote down it.
yes. You tell me.
Okay, sir.
You tell me if there is a link.
No, sir. If it is wrong, I will quote down it, sir.
Yes,
Otherwise,
please.
in future, I could make any mistake, sir.
No, I'm seeing you are putting questions which are not relating to the uh, topic that we are discussing. You are putting questions from 148. If in that case, I can put you any question, I am sure you will not be able to answer. So don't put questions
No,
for the
sir. I
sake of
have
it.
not read CPC, sir. I have not go through CPC whole, sir.
Then why did you ask 148 CPC and the link between 148 CPC and Order 6 Rule 17?
Sir, anywhere I have written
Anyway,
section 148, sir.
to cut it short, if anyone else has
Okay,
any
sir.
doubt, they may please ask,
Okay. Thank you,
or
sir. I am
will.
leaving, sir.
Yes, please.
Good night, sir.
Yes, Shravani has a doubt, I believe. She has raised the hand. Please ask, Shravani.
Hello, sir. So
Yes.
actually ସେ rule 6 ଟା actually ବୁଝିପାରିଲିନି ସେ ଯୋଉ condition precedent ଟା କହିଲେ
ମୁଁ ସେଥିରେ କଣ କହୁଥିଲି କଣ୍ଡିସନ ପ୍ରେସିଡେଣ୍ଟ ଟା କଣ ଯେ ତାର ଇଟ ସେଜ ଦ୍ୟାଟ ଆପଣଙ୍କର ଯଦି ଗୋଟେ କଣ୍ଡିସନ ପ୍ରେସିଡେଣ୍ଟ ଟାକୁ ଆପଣ କହୁଛନ୍ତି and you are alleging that a condition precedent has not been followed or the performance of the condition precedent has not been done, then you have to specifically plead it. ଯଦି ଯଦି condition precedent ର performance ଟା ଆପଣ ହେଇଯାଇଛି, then you did not plead it. condition precedent କଣ, ମୁଁ ଆପଣଙ୍କୁ example ଦେଲି. for example ମୋ ବାପା କହିଲେ that ମତେ ମୁଁ ୟୁପିଏସସି କ୍ଲିୟର କଲେ ମତେ ସେ ବାଇକ୍ ଟା ଦେବେ और ମୋ ଫେଭର ରେ ସେ ମାନେ ପ୍ରପର୍ଟି ଟା କରିବେ, ବଟ୍ ଯଦି ସେ ପ୍ରପର୍ଟି ଟା କଲେନି, ତାପରେ ମୁଁ ଗୋଟେ ଏବେ ସୁଟ୍ ଟେ କରିଛି ଯେ କାହିଁକି ସେ ମୋ ପ୍ରପର୍ଟି ଟା କଲେନି, ଅର୍ ଫର ଦ୍ୟାଟ ମ୍ୟାଟର ମୁଁ ଗୋଟେ ସ୍ପେସିଫିକ ପରଫର୍ମାନ୍ସ ପାଇଁ ସୁଟ୍ ଟେ କରିଛି ଅର୍ କିଛି ବି। ତ ସେଇ ଯୋଉ କଣ୍ଡିସନ ପ୍ରେସିଡେଣ୍ଟ ର ନନ୍ ଫୁଲଫିଲମେଣ୍ଟ ଟାକୁ ମୋ ବାପା ଏବେ ଆଲେଜ କରିବେ ଦ୍ୟାଟ ସେଇ ଯୋଉ ନନ୍ ଫୁଲଫିଲମେଣ୍ଟ ପାଇଁ ମୁଁ ତାଙ୍କ ତା ଫେଭରରେ ପ୍ରପର୍ଟି ଟା କଲିନି, ସେଇ ଯୋଉ ନନ୍ ଫୁଲଫିଲମେଣ୍ଟ ଟାକୁ ତାଙ୍କୁ ସ୍ପେସିଫିକାଲି ପ୍ଲିଡ୍ କରିବାକୁ ପଡିବ। ଆଉ ଯଦି ଫୁଲଫିଲମେଣ୍ଟ ହେଇଯାଇଛି ଦେନ୍ ହି ଡିଡ୍ ନଟ୍ ପ୍ଲିଡ୍। ବୁଝିପାରିଲେ?
ଆଜ୍ଞା ଆଜ୍ଞା।
ଠିକ ଅଛି। ଆଉ କିଏ, ଆଉ କିଛି? Abhipsha has a doubt, please ask.
Sir, can you once again clarify upon alternate versus inconsistent that we discussed under Rule 17? Sorry, Rule 7.
Yes, alternate versus inconsistent. So, as I told you, there is a very thin line between alternate pleading and inconsistent pleading, or alternate relief claimed or inconsistent relief claimed. For that matter, one example, I'll give you another example. That if I am alleging, I'm pleading that I am having the title of this land. The next pleading of mine is, as nec clam, nec vi, nec precario, all these three conditions are satisfied, I am claiming adverse possession over this land. All these three conditions, these two conditions are the two pleadings that I pleaded. These are inconsistent in nature. Hence, I can't. These are called inconsistent pleading. The court has to see whether these are allowed according to law, and hence the court may allow the same to be there, or if the court thinks that these are such inconsistent that they can't exist according to law, then those are to be struck down. Another example would be से जो contract ର example देली, that ଆପଣ contract ରେ ଆପଣ କହୁଛନ୍ତି ଯେ the consideration is unlawful and that's why it is a void contract, and the next pleading of mine is that it is I want the specific performance of the same. On one hand, I'm alleging that the contract is a void one. On the other hand, I'm asking for a specific performance of contract. These two are inconsistent pleadings. But in the opposite side, the alternate pleadings would be where I am seeking one relief, but those must be in the different forms, because the alternate relief the alternate relief probably seems like same. Alternate pleading seems like the same as inconsistent pleading, but then why the alternate pleadings will be allowed and inconsistent pleadings can be struck down by the court if the court thinks fit? That is because alternate pleading and inconsistent pleading re difference ho jaya. If you alternate pleadings को allow not करिवे, then it will not give finality to the litigation, because as जो example देली rent रो eviction करिया पे मते house मो landlord चाहुचंदी, my landlord gave me a notice जहाँ भी to evict हेलानी, तापर से जोड़े suit ते कला परे he is alleging that I want to evict the tenant. Why? He is not paying the rent, that's why I am evicting him. In the next pleading he is writing that also my sister is coming from US and that's why she is going to stay in that house, and that's the reason I want to evict the tenant. These two are alternate pleadings, because on one hand the landlord is claiming that he's not giving rent and that's why he is evicting. On the other hand, he is saying that because my sister is coming from US, that's why I want to evict. So these are two alternate pleadings. So these things you have to take a note and take care of, so that it will be alternate pleading ଆଉ inconsistent pleading ରେ differentiate କରି ପାରିଲେ ସେଇଟା ହେଇପାରିବ ଯେ ଆପଣ either you will be striking them down if the case may arise, or you may go ahead with the same as if there is no bar in the law whatsoever. I hope I am clear to you?
Yes, sir. Thank you, sir.
Okay. Okay. Thank you. It's already 8, so let's wind up the session. Thank you. We'll meet tomorrow.